I think we should start, yeah, because we have just 50 minutes and the schedule is really tough. Topic of our session is Russian counter-sanctions responding to EC and the US sanctions against Russia, and namely recent amendments into Russian commercial procedural code. So the amendments called here in Russia amendments by Lugovoy, you know, this notorious figure. And so these amendments, the essence of these amendments, they allow Russian entities which felt under Western sanctions to drag the disputes in Western jurisdictions, either arbitration or litigation, to drag them into Russia, into Russian courts. And I introduce my co-panelists, Yaroslav Klimov, partner of Norton Rose firm, and Konstantin Kroll, partner of Dentons firm. So both lawyers focused on litigation and arbitration. So the topic is really of great importance for us. And I pass the floor to Yaroslav Klimov, who will start with introduction of the amendments. Please, Yaroslav. Just few words, few technical remarks. So for the attendees, so if you want to ask us any questions, so please don't hesitate. So you may either raise your hand and speak loudly, or leave your questions in the chat. And so we leave enough time after each block of our discussion for your questions and our comments. Yaroslav, please.
Thank you, Maxim, for the introduction. Hello, everybody. Indeed, on the 19th of June this year, there were new rules introduced to the Russian Arbitrazh procedural code relating to the new possibilities for the Russian sanctioned persons to drag their disputes to the Russian state commercial courts. These disputes were introduced very recently. As you can see, they are represented by two new articles to the Russian Arbitrazh procedural code, namely 248.1 and 248.2. And these two articles, they raised a lot of discussions in the Russian legal and business community. I will speak about the first article, 248.1. But before doing this, I would like to just to express my view that, of course, and I think it's not only my view, the main objective of this law was to protect the interests of the Russian sanctioned persons, both natural persons, legal persons, and enable them to consider their disputes with foreign parties, their disputes abroad, by the Russian state commercial courts. And I think we need to bear in mind this task when we interpret the new provisions. So the new article 248.1 immediately raises numerous issues of its interpretation. This article introduces the exclusive jurisdiction of the Russian state commercial courts over disputes involving Russian natural and legal persons. Thanks God, this exclusive jurisdiction is not absolute, according to this article, and it exists in two situations. First of all, when there is no arbitration or prorogation agreement between the parties, and frankly speaking, I think that it's quite rare in international transactions involving Russian parties. And secondly, the exclusive jurisdiction would exist when there is a valid arbitration or prorogation agreement with seat outside Russia, but it becomes unenforceable as a result of restrictive measures creating obstacles for access to justice. I think this second precondition for the exclusive jurisdiction would be much more relevant and would be seen much more often on a legal scene. Of course, the problem is that this new article introduces the term restrictive measures. We all understand, and I think it's presumed that this article is related to the sanctioned persons, but instead of the word sanctions, the term sanctions, the lawmakers introduced here into this article the term restrictive measures without, in fact, limiting them. So what kind of restrictive measures there might be? Any kind of measures, because there is no limitation or definition of these measures, let's say, by their forms. It can be secondary measures, it can be sectorial sanctions, it can be individualist, etc. And it remains to be seen how Russian courts will interpret this broad term restrictive measures. I think we will see a very broad interpretation. Also, the situation is, or the interpretation of this term becomes more difficult because there is no distinction, there is no limit by the bodies who might take these measures. These measures, according to this article, might be taken by any foreign state, association, intergovernmental organization, etc. So you can see that the Russian lawmakers decided to put a term which would be almost universal for all future situations, and would have the maximum coverage in terms of their forms and imposing bodies. Which persons can be subject to this restrictive measure, and subject to this exclusive jurisdiction? Of course, primarily these are the Russian legal entities and Russian individuals against whom these restrictive measures have been introduced, but also it relates to the non-Russian legal entities against whom restrictive measures have been introduced in connection with the restrictive measures imposed on Russian entities and individuals. So I think the purpose of this category is to protect the interests of the foreign subsidiaries of the Russian sanctioned entities, so that they can also effectively resolve their disputes before Russian state commercial courts. Another issue is that there is no time limit for application of the new rules. Today, when foreign and Russian parties are negotiating an agreement and introducing, let's say, an arbitration clause for ICC in Paris, these new rules might not be applicable, might not be relevant to them. They can definitely agree on this. However, in 1 year time, if for whatever reason there are any restrictive measures against the Russian party, then these new rules would become relevant for both Russian and foreign parties. And in fact, for the foreign parties, it might be indeed relevant because they might end up in finding themselves before a Russian court rather than ICC in Paris. And I also think that we will see the cases when the Russian parties will try to apply these new rules retrospectively. So they will argue that these rules are applicable to their arbitration and prorogation agreements concluded before these new rules entered into force. And I also think that we will see the Russian courts applying these rules retrospectively. Another interesting point related to this new Article 248.1 and its interpretation is the used wording arbitration outside Russia. Of course, yes, this wording is indeed not very clear, and there are different interpretations of this wording. Bearing in mind the purposes of the Russian arbitration reform to bring as much more disputes to the Russian territory, I think personally that this wording arbitration outside Russia covers all foreign-seated arbitrations, which are administered both by foreign and Russian arbitral institutions. There is a view that this wording is also covering the arbitrations which are seated in Russia but administered by foreign arbitral institutions. And of course, it remains to be seen how the Russian courts will interpret this. But my personal view is I don't think that such a broad interpretation will take place, because otherwise, I think it will undermine the position of, for example, HKAC or DIAC, who have now the status of permanent arbitral institutions in Russia and can administer certain types of disputes here on the ground. Another important issue for interpretation by the parties and by the courts is the question how to establish the unenforceability of the arbitration prorogation agreement with seat outside Russia. According to the wording, it's the unenforceability due to application of restrictive measures which are creating obstacles for access to justice. My colleague Konstantin will give you examples and will speak about the obstacles for access to justice, but before handing over to him, I would like to say that itself the issue, the interpretation of establishing the unenforceability would create a lot of problems before Russian courts, because we have no clear case law as to when an arbitration clause is to be deemed unenforceable. And frankly, I think that there is a risk that these new rules would be applied for the purpose of unenforceability by the Russian courts also in situations where an arbitration clause might be not enforceable due to other reasons than the sanctioned status of Russian party. Konstantin, over to you for the obstacles for access to justice.
Yaroslav, thank you very much for a very good summary of the essence of the provisions. And as you rightly pointed out, the sanctions, they can be very different. So there is not just one set of sanctions. There can be what is called sectoral sanctions, both in the context of the US sanctions or the EU sanctions implemented in relation to Russian entities and persons. And of course, there are the so-called blocking sanctions in the US context, or the so-called smart sanctions in the EU context, which is another equivalent of individual sanctions. The reason I touched upon that is because the practical implications of impact of sanctions really depend on the essence of sanctions in questions. So in terms of what are the problems with the access to justice that may arise, I would divide them into two sort of big principal areas. One is sort of theoretical legal problems, which is whether, in my view, the problem is whether sanctions is effectively a type of overriding mandatory provision of applicable law of the contract or applicable law of the seat of arbitration. So, for example, to put us into context, let's say contract is governed by English law and the seat of arbitration is London, which is a very common choice in cross-border transactions involving Russian parties. So, and as we know, the UK, which is still part of the EU adopted sanctions in relation to various Russian entities. So there might be an argument that these sanctions are part of overriding mandatory provisions of English law applicable to the contract. So it's an important issue, but because we limited in time, so let's talk more about the practical issues that may arise. So there are plenty. So when parties go into dispute and conduct arbitration, what they need to do, they need to appoint the arbitration tribunal. They need to appoint arbitrators. They need to instruct legal counsel. They need to involve experts. They need to involve witnesses in the proceedings. They need to pay arbitration fees, whether to the permanent arbitral institution forum or to the ad hoc arbitrators. They need to pay legal counsel. So all these sort of practical steps may sound sort of very standard and routine, but in the sanctions reality, pretty much all of them may become a real problem and issue. Starting with the appointment of the arbitrators, if arbitrators are individuals from a jurisdiction which impose sanctions, and these sanctions are, let's say, blocking sanctions, then arbitrators will not be able to accept appointment unless they get a permission, or it is often called license, from the authorized authority in their jurisdiction. So we all know in the US, it's OFAC, which is part of the US Treasury, which is authorized to grant such licenses. In Europe, there is no just one body. Each member state would have its own, which would need to grant permission. If we take US as an example, there is no guarantee that such permission or license would be granted. And even if it will be, and there are examples when licenses were granted, there can be absolutely no predictability as to the timeline for such license being granted. So that creates a lot of uncertainty. Then, of course, instructing legal counsel, again, same problems for law firms. They would want to comply very strictly with the laws applicable to them, whether if they're registered in the jurisdiction which impose sanctions, or whether they have an office there, which is relevant to most large international firms. And of course, there are also reputational issues. You see, sanctions, with blocking sanctions, it's clear that you cannot touch that entity or individual. With sectoral sanctions, it's much trickier, because technically there is no restriction to provide legal advice or arbitrator service to an entity under sectoral sanctions. However, such a routine thing that your fees as counsel or as an arbitrator, they need to be paid. So if you issue invoice and if it's not paid within two weeks, then this can be recharacterized as sort of form of trade finance, and that would breach the sectoral sanctions. So effectively, you would be financing the party, and that would create a problem. There are many more examples like that. But if we go on, so experts, same issue. Witnesses, if a witness is under, say, blocking sanctions, then it's very likely that witness will not be able to get a visa to travel to the jurisdiction where he or she might need to give evidence. Of course, in the COVID environment, you would argue that, well, everything will be done by video conference anyways. And that would probably be fine, provided all parties, witnesses, give evidence this way. However, if one party is able to be present and the other needs to be present by virtue of video conference, that in itself may raise issues as to whether the parties had equal process and equal possibility to present their case. And if not, then there is an argument that it was not due process. And now, of course, the payment of fees, costs, and expenses, if the currency of payment is US dollars or euros, that again can be very problematic if a party is under sanctions, because as we know, payments in dollars, banks would not process payments in dollars if a party is under sanctions. So all of this is a non-exhaustive list of examples as to how sanctions can become a problem. And as we know, many Russian parties under sanctions face these difficulties and try to overcome them with various degrees of success. And actually, even before these changes to the arbitrage procedure code, there became a trend where some Russian parties, in particular state-owned, or those who, for various reasons, consider themselves as in high-risk zone for potential sanctions, started looking at arbitration forums in Asia, less common previously, such as Hong Kong and Singapore, probably to minimize the impact of sanctions. But we will talk more about that probably at the final section of our presentation, and I will pass the floor now to Maxim to cover the second article dealing with the new regime. Thank you.
Okay, thank you, Konstantin. Before I turn to second part, of this article, I invite the audience asking questions. So again, so you may raise your hand and speak loudly, or you may leave your question in our chat. And while I'm thinking about your questions, so I have a question for Yaroslav. So the key words in the part 4 of this article is like arbitration outside of Russian Federation. So you already touched on it, and so it's quite obvious if it's say ICC arbitration in Paris. So it definitely falls under arbitration outside Russia. And am I understood you correctly? If it's ICC with a seat in Moscow, you think it also come under arbitration outside Russia, or what?
No,
ICC
I would say
seat in Moscow. Yeah.
Well, not necessarily, but I think it might be a problem from the point of view whether the ICC is administering dispute and doesn't have the status of the permanent arbitral institution. I think that's the question. But from my perspective, the wording arbitration outside Russia covers all foreign seated arbitrations administered by foreign arbitral institutions, but also by a Russian arbitration, like International Commercial Arbitration Court, the Chamber of Industry, Commerce. So I think an arbitration, foreign arbitration administered by ICAC would fall under this scope.
I see. So if it's an ICAC, let's imagine it's a quite unimaginable situation. ICAC with a seat in Paris, so it would fall under arbitration outside Russia, correct?
Yes, I think from my interpretation of this article, yes, it would fall into this category.
Okay, and I think that following from what Konstantin said, if it's ICC with a seat in Moscow, it also would fall under arbitration outside Russia, because most of the difficulties Konstantin mentioned, so they linked to not even to a seat of arbitration, but to arbitration center, arbitration institution, which provide facilities, so like taking payments, appointing arbitrators, and so on. So I'm afraid that this law provision would be interpreted in the most wide sense. So any arbitrations with seat abroad and any arbitration with seat in Russia if they are administrated by a foreign arbitration center, I'm afraid.
I agree with your views. I think in case with the ICC, it will be indeed the case. But, well, from my point of view, it will be interesting to see how this might be applicable to the arbitrations administered by HKAC or VIAC in Russia.
Mm-hmm.
Because I think it should be a differentiation. Of course, the proposed wording doesn't solve this problem at all. It just refers to more or less the territorial let's say, characteristical. But it would be strange from my point of view if VIAC and HKAC would be treated in the same way as ICC, because then there is a question, what gives them the status of the permanent arbitral institutions in Russia?
I see, yeah, so it would be pointless, yeah. So we
Absolutely.
Such a long and exhausted way to get permission of Russian government just to come to such sad end. Okay,
So,
the audience, yeah, so do you have any questions regarding this blog before we turn to the next one? I see among of you it's quite a lot of lawyers who might be really interested in this topic. Yeah, so it means that you either know everything about the topic, even more than us, or something else. Okay, so please feel free to leave your questions in chat or just raise your hand. So next block is that's the second part of this article, so namely 248.2. And that's quite unusual novel in Russian legislation because this is about anti-suit injunction. You know, we've heard a lot of criticism about this Western tool from Russian lawyers and judges that we don't like anti-suit injunctions because they deprive people from the basic right to apply to justice, and so justice is for everybody. So one court cannot prohibit a person to apply to another court. But suddenly, this tool started working in Russian law due to these amendments, and namely, so Yaroslav, so he explained the rule, and the second part of the rule is the sanction for breach of this rule. So it means that if a foreign entity, notwithstanding a Russian court ruling prohibiting that entity to initiate or proceed with a foreign arbitration or litigation, so a Russian court may impose a fine against such a person in the amount of the claim of that person. So, for example, if, for example, American company commenced LCA arbitration against, say, well, any Russian sanctioned entity in the amount of, say, $1 billion US, and under application of Russian entity, Russian court prohibited such American company to proceed with this LCA arbitration. So Russian court may impose a fine in the amount of $1 billion US against that American company. I'm quite sure that such a decision of Russian court imposing a fine against a foreign entity would be unenforceable in most of the countries, but definitely it would be enforceable in Russia. So it means that in some cases it could be dangerous and it could be quite effective tool if it's enforced in Russia. So this new law provides more questions than answers. So, for example, if this fine is, the amount of this fine is at the discretion of Russian judge, or it's only in the amount of claim a foreign entity brought. So if it's 1 billion, so the fine is only 1 billion, because the law is silent about it, if it could be like $500 million or less. And second, it doesn't give any transparent and stable criteria what is a clear ground to impose such a fine, because the law said just three very general criteria. So the first one is just a second. That's criteria of is just justice, reasonability. Yes, justice, reasonability, and the prohibition to make profit from unlawful act. So what does it mean? We don't know. So. But most likely Russian courts would impose the fine exactly in the amount of the claim of that foreign entity. So far we don't have any cases on imposition of a fine, but we have 3 cases which somehow linked to this new law. You know, the first one was Instar Logistics. a Russian company. So they brought, so they had a claim against American company Neighbors Drilling, and all the disputes were referred to ICC rules. And Instar Logistics, they brought claim to Russian court, challenging such a dispute resolution clause due to its non-enforceability in opinion of Instar Logistics. Because they were under sanctions, so they couldn't really enforce ICC clause. But the problem is that from the court decisions which hold this dispute resolution clause unenforceable and therefore invalid, we don't have any information if Instar Logistics, even if they try to enforce this clause, even if they try to commence arbitration under the ICC rules. The only reason I managed to find in the court judgment is that as Instar Logistics is under sanctions, so it cannot enforce ICC award in favor of Instar Logistics because no money would be transferred from American banks because all transactions are frozen. And it's not absolutely clear, it's not clear at all. Well, if we have a Russian judgment in favor of Instar Logistics against American companies, so how this judgment would be enforced outside of Russia. So I think it would be even more difficult to enforce it. So the second question case is Russia Today against Barclays Bank. You know, this TV channel Russia Today, quite famous in certain circles. And its boss, Vladimir Kiselov, is under sanctions now. And therefore, Barclays, they've frozen all the accounts of Russia Today. And Russia Today, so they brought a claim against Barclays in a Russian court, claiming to release the funds. So one of the arguments on the later stage, on the stage of cassation, was a reference to this new law. But the court declined the claim, and well, one of the reasons was that the law came into force half a year later when the case was considered by the first instance court. So the law is not applicable to this case. We don't know how it would be if the case in the first instance is heard right now. And the third case is Ural Vagon Zavod against, that's a Russian company, military company, and so military equipment. And they brought claim against Polish company PESA. So PESA contracted to deliver some infrastructure, I think vehicles for Moscow. And the contract between them provided for Stockholm SCC arbitration clause. And Ural Vagon Zavod, so they claimed that this clause is unenforceable due to the fact that they are under the sanctions. And the cassation court a couple of months ago pointed out that the new law should be considered by the lower court and sent it for reverted it for new consideration to the first instance court, and so we expect the first instance court decision very soon, I think in a couple of weeks. And perhaps this case would be a first probation of a new law. And an obstacle, one of the obstacles Ural Vagon referred to was that they couldn't contract good lawyers because most of the lawyers, so they denied providing their services because Uralvagon is under sanctions. So we'll see it. Okay, any questions from the audience? Yeah, I don't see anything in the chat, so we turn to the third and the last block of our discussion. So it's about what to do, how to mitigate the risks, or how to get benefits from this law. Konstantin, please.
Thank you, Maxim. I'm going to speak about one of the possible solutions, which, in my view, could work, and that potential solution is choosing the Hong Kong International Arbitration Center as the forum for considering disputes out of your contract. And the reasons for that is that, well, first of all, of course, Hong Kong is one of only two non-Russian permanent arbitration institutions which are sort of recognized and licensed by the Russian Ministry of Justice. And that in itself gives it sort of certain sort of credibility in the eyes of the Russian judiciary, in my view. But compared to VIAC, which is the other foreign institution, VIAC being in Austria being a member state of the EU, so there are European sanctions which are applicable. By contrast, Hong Kong has not imposed any Russia-related sanctions. In my view, that unique status of a permanent arbitration institution coupled with the absence of sanctions would make it much more difficult for a party to argue that its access to justice was limited if the dispute was considered by HKIAC. Having said that, as I mentioned earlier in the earlier part of my presentation, there are certain problems with the access to justice that may not be solved by choice of Hong Kong or indeed Singapore, because if payment, for example, needs to be done in dollars, then Hong Kong wouldn't help, because the banks would still probably froze or otherwise not accept the instruction to make a transfer. There will be same considerations made by the arbitrators and legal counsel. If a certain arbitrator or legal counsel is from the US or from the EU, they would still be very careful and considerate about complying with the sanctions. So the choice of forum in itself may not be a solution. However, I think it would open up many other doors and choices for the parties. So and the best solution would be to consider a dispute in Russia. So that is probably bulletproof. All other solutions are not bulletproof, but at least it gives it gives certain hope. And of course, a lot will depend on how the practice in Russia evolves, how courts are going to interpret what access to justice is and how it can be limited. But I think that Hong Kong is one of the possible solutions. Thank you.
Konstantin, thank you. I see an interesting comment from Roman Zykov in our chat. That, so he wrote that the currency would not matter either. And Hong Kong Bank would not accept payments of fees from a sanctioned company, even in Chinese yen. So what do you think about it? As I see, Roman's point is that the key problem is payments of arbitration fees and similar payments. If a sanctioned company, no bank outside of Russia would accept payment from a Russian sanctioned company.
Well, maybe a Hong Kong bank like HSBC, which is of course a Hong Kong bank, would not. But frankly, I don't know. But I think that there might be banks without international exposure who might make a transfer. Frankly, I don't know. But if there is no possibility to make payment and there is no license from an authority, then it's a perfect example of limitation of access to justice. Then yes, then the new provisions of APC would probably apply in these circumstances.
I see. Well, maybe I see Roman raised his hand. Roman,
I'm here.
Please, comment on it.
Yes, thank you for the great discussion. I would disagree with the with Hong Kong or any other place of arbitration. It doesn't make much difference because most of the arbitration institutes have declared that they have no problems with administering the disputes from the sanctioned companies, be it the ICC, Stockholm, London, etc. But the impediment here is how to pay the fees. None of the, because they would use a Swedbank or they would use, I don't know, whatever, HSBC, any other bank, even a local bank would refuse to accept money from a sanctioned company. And that's exactly my experience. It worked well in the ICC because they used a policy exemption under the French law, and they applied for a license specifically for our clients. And they used a very local bank with no exposure. It was like a Parisian bank, a very small one, to accept the fees. But many other institutes don't even bother to try to look for a very independent and local bank to accept the fees. They just simply say, no, we are not going to accept your dispute. And for example, that was the case with Stockholm recently, and we've been struggling for half a year lodging a claim on behalf of a sanctioned company. Not under the EU sanctions, but under the US sanctions. And Stockholm said, well, we are not going to jeopardize our entire business because of one company, so apologies, I'm not going to do anything. So that's largely the problem we have. It's the payments, not the institutions. Thank you.
Thank you, Roman. So maybe the solution is to drag all your disputes into Russia and trust into Russian courts and arbitrations. Yaroslav, what do you think about it?
Yes, Maxim, I think it's indeed nowadays the safest option. It might not sound very attractive for the foreign parties, and it's very often international transactions that they do not want to agree to arbitrate in Russia. But if just balancing between the risks of being subject to exclusive jurisdiction of the Russian state commercial courts and still be able to arbitrate, I think, unless we see other developments, so far the safest option would be to enter between the parties into the arbitration agreement for a Russian-seated arbitration administered by a local arbitral institution, like, for example, ECAC or the Russian Arbitration Center or the Arbitration Center, the Russian Union of Industrialists and Entrepreneurs. So I think this would be the safest options, whatever, doesn't matter how the parties would, let's say, accept this or not, but it seems like the most safe solution so far. And then taking this decision, following this option, I think then they have to try to adapt these proceedings, a local seat arbitration, mostly to the Western standard by, let's say, nominating foreign arbitrators, etc. But so I think that's the most safest solution right now.
I see. Thank you. Well, of course, it might be a solution, but you know, as some one prominent lawyer said half century ago, that arbitration is as good as the arbitrators are. So it means that if your arbitration is under ICC rules or ICAC rules, it's important, but much more important not which rules you use, but who are the arbitrators. Yeah, so if you have really good arbitrators, so you can be sure that the award will be of a good quality. But we see that there are at least two big problems with arbitrations in Russia. So first is they're subject to annulment so in Russia, so they can be set aside by Russian courts, and it takes place quite often. And second, that a procedure of appointment of a chairperson is quite often is not transparent and not exactly unclear. So that's the second problem with arbitration in Russia. So if you don't want to arbitrate or litigate in Russia, perhaps you have to think about, well, first, the way how to enforce your future judgment or award outside of Russia. So if you have a contract with a Russian entity, a sanctioned entity, or which might come under sanctions, so you have to think about any securities or other ways to guarantee the enforcement outside of Russia, so you don't have to apply to assistance of Russian courts. And second, you have to make sure that you don't have any assets in Russia. So it means that if a Russian court would impose a fine against you because you don't follow Russian anti-suit injunction, so this fine will not be enforced against you. Well, and I see Victor Prokofiev would like to ask a question. Victor, please.
Hi, thank you very much. Well, first of all, thanks a lot to all the panelists. Wonderful presentations. My apologies, I was slightly late in joining. I may have missed out on something. My question is, with respect to the payments, and this, amongst other things, goes back to what Roman Zykov mentioned. Do I take it that the problem only arises if the payments are made in dollars, because that goes through the US banking system? And can that be obviated by means of making payments safe in Swiss francs, where it goes through a Swiss bank? Thank you.
Victor, as I understood from Roman, so the currency doesn't matter, yeah. So it could be even a Chinese currency. Well, I see that two attendees raised your hand, so please, maybe you can comment on this question. So who?
Yeah, it's Roman Zykov back. Thank you very much. Just a very short intervention. The way it works is that a bank manager sits and sees a transaction, incoming transaction. So the system shows that, okay, well, the compliance system of a bank shows a red alert that this company is under the US sanctions, although the bank might be in Switzerland. So what a bank clerk does, the bank clerk simply rejects the transaction or moves it to the compliance department. And the compliance department would do the same. They would look into the transaction and say, well, it comes from a Russian sanctioned company. Let's deny it, irrespectively of the currency. We just don't want to deal with that company. As simple as that. So that's the major impediment, the banks. Thank you.
Got it. And does that mean that the only way then to appeal against that would be to go the French way, as I think, Roman, you also mentioned?
That would be one of the ways, but again, it requires a very close cooperation between the arbitration institute and the bank. And the institute would apply for a license from the state and then communicate it to the bank and say, well, here's the license, we can deal with this company on this ad hoc basis, specifically for this amount of payment, and that's it. And if you can convince the bank and the bank accepts the money, then the arbitration institute will administer the case, not the way around.
Got it. Thank you very much.
Could it be a solution if the other party pays all of the fees? Would it be possible?
Will you make a respondent pay the fees? Doubt it.
No, but if the claimant is willing to pay the fees of the respondent.
Konstantin, well, I'm afraid not. Well, the case I mentioned, Ural Vagon Zavod against Polish company PESA. So actually, Ural Vagon Zavod mentioned two points. So the first one, that they couldn't find a good lawyers to assist them in that case, and second, that they couldn't pay any fees. And as I understood from Russian court judgment, that the fees were paid by PESA. So PESA the claimant in that case, and so they just paid all the fees on behalf, so the respondent's part of the fees. So the only problem remain is legal assistance. Yeah, so they couldn't find a good lawyer. But again, from the court judgment, it's absolutely unclear. So if literally the court judgment mentioned that in most of the cases, lawyers declined the instructions. So it means that in some cases they didn't decline the instructions. So it means they, in fact, they could find some lawyers, but we don't know any other facts. But I'm afraid even this obstacle would be considered by Russian court as enough to drag the case into Russia. Well, we see the progress of Ural Vagon Zavod case in a couple of weeks. We'll see what will be the first instance decision on it. Well, I see that our time is over, unfortunately. And I would like to thank my co-panelists, Yaroslav and Konstantin, and thanks all the audience, especially those who was asking questions. It's always interesting for everybody to discuss something. And so I hope those who can get benefit from this new law will get it. And those who want to escape these new law restrictions will escape. Thank you very much for your attention. Good luck with the rest of the conference.
Maxim, thank you very much for your presentation as well and for moderating this session. Thank you.
Thank you.
Thank you.
Yeah,
thank you, colleagues. Thank you.
Bye-bye.
Bye. Goodbye.